happened to see the requested budget by the Obama administration for the Department of Labor a couple weeks ago? Well, it's very telling. The actual requested amount for the entire Department of Labor is $12.1 billion. And of that amount, they're asking for an increase for the wage and hour division alone of $16 million. They're asking for an additional $3.4 million just to pursue violations of the Fair Labor Standards Act and the Family and Medical Leave Act. They want $14 million for them to pursue misclassification issues. And they want an additional $5.9 million just to pursue whistleblower issues. I think this is very telling. We all know that the Department of Labor has really ramped up in the past couple of years, but this is an obvious emphasis in wage and hour enforcement, an obvious emphasis that's laying out where the administration intends to target us for 2014. And I think it tells us where its priorities are. So if you haven't had a request from the Department of Labor to enter your premises, for them to conduct an investigation, you very likely will. It's really not when, if, but when these days. Don't you agree, Paul?
Yeah, I do. And I think just to follow up on the point that Kathy just made, you know, the interesting thing about the budgetary numbers to me is that this is a year of supposed cutbacks. This is a year when the budget was supposed to be trimmed. This is a year where we are focusing on fiscal responsibility and decreasing the amount of money that the government spent. But despite that, we have what are pretty dramatic proposed increases for the Department of Labor. And so,
and who knows where that'll end up.
That's right.
I mean, you know, it's just a request at this point.
But it should give us a pretty clear idea that the administration is going to continue on the path that it's been on for the last several years to really increase the presence of the Department of Labor in our lives. So probably a good idea at this point is to just talk a little bit about the Department of Labor and what you might be exposed to if you do get a Department of Labor audit. How many of you, just show of hands, just out of curiosity, how many of you have had a Department of Labor audit in the last several years? A lot of hands. That's a bunch of folks. And I'll tell you, I have seen a dramatic increase, at least in my practice, in those Department of Labor audits. And we'll talk about where those come from and how you might be subjected to one. But the important thing for this slide, at least, is to remember that the Department of Labor, the United States Department of Labor, is responsible for administering 180 federal laws. 180 federal laws. The ones that we're typically worried about in this room are the Fair Labor Standards Act, the FMLA, OSHA, maybe the MSHA, which is the Mining Safety and Health Act, but those are the more common ones that we deal with, but there are many, many others. And my experience, especially in the last couple of years, has been that when a Department of Labor auditor comes to see you, you are going to get audited for just about every one of those things. It's pretty impressive, the list of questions that those auditors come with and the materials that they want to see while they're in there. Now, there's several divisions in the Department of Labor, of course. We have the Wage and Hour Division, which is the one we deal with most often. We have OSHA and MSHA. We have the Vets Office, which deals with USERRA and some of the other veterans-type benefits that the Department of Labor enforces. But the way that these investigations are happening more commonly is that we are not getting just a whole heck of a lot of notice about these audits. We're having an auditor show up with a letter in hand, provides you notice that you're going to be audited and you have 24 hours or 48 hours to be ready. Now, sometimes we can negotiate a slightly longer response time, but not very much. And so it becomes critically important for you to have your wage and hour documents in particular or your information available and organized so that we can respond in a timely manner. You could get a phone call from a labor investigator who could give you verbal notice of an audit, but again, you will not have much time to prepare for those things. Typically, over the last year or so, and what appears to be happening in the future and what will continue to happen is that the Wage and Hour Division in particular is targeting specific industries for audits that are what they call routine. So you may or may not be accused of actually doing something wrong, but just get an audit simply because you're a member of a specific industry, and those might be low-wage industries like hospitality, hotel, restaurant management type industries. Those are very common. Nursing home audits are very common right now, and other healthcare agencies. And those targeted audits are becoming more and more common. And that it's not like the typical case that we used to have where it was simply an employee complaint was most likely the only reason you would be audited. Those still happen too, obviously. And then the goals of the Department of Labor, very public, very clearly stated on just about any materials that you see. The Department of Labor considers itself the protector of the worker. And that it is not a neutral agency, and it hasn't been for some time. It really sees itself as an advocate for employees, and you should understand that as you go into an audit. You are, and should be, on the defensive, and that's why you need to be prepared for these things in advance. Just because I know from watching Tony's presentation, I'll wake you up. You should use prophylactic measures and be prepared. Okay. Moving on then, the current hot topics for investigations and audits in the Department of Labor right now, misclassifications are a big topic. This has been a big topic for a couple of years, so this is nothing new, but it is something that you should be aware of. You must know whether your exemptions are appropriate or not. You must have gone through some analysis to make sure the employees that you're treating as non-exempt are properly classified as non-exempt. The same thing is true for independent contractors. There are a number of you in the room, and I will not ask for a show of hands here, but I know that you have people that you classify as independent contractors for a number of reasons. Maybe it's for workers' comp issues, maybe it's for withholding issues. I will promise you there are a number of you in the room that have improperly classified independent contractors. There's a complicated test that we go through to evaluate that, but if you have any doubt in your mind about whether that's appropriate, you need to talk through that with your counselor, because this is a continuing hot-button issue. In fact, recently I noticed that the Department of Labor has actually entered into a partnership agreement with the states and is providing money to the state agencies for the purpose of pursuing these misclassifications when it comes to independent contractor status. Basically, the idea here is you, Mr. State Law Government, can collect a lot more in taxes than you have been collecting if you will go after the people that have these misclassifications. So we're going to encourage that. We're going to give you money for the purposes of pursuing that. Off-the-clock work continues to be a very big topic when it comes to the wage and hour division. This is something that if you're not very carefully managing the process of when your employees are working off the clock, you need to give that some thought. This has become an issue as technology has become more and more available. Email is available, cell phones are available, work-at-home connections like Citrix are available. You've got to make sure that you have clear policies about off-the-clock work and that you're paying employees when they're working. If not, you can find yourself in a collective action, which is as some of you know all too painfully, a big headache and a significant investment of your time. And then FMLA compliance continues to be a big issue. Certainly new regulations have gone into place in the last few months. We've got new posters that need to be publicized. I just finished a Department of Labor audit not a month ago, and the very first question the auditor asked when she walked in the door was, "Let me see your posters. I want to see if you have the new FMLA poster posted where it belongs." That directive had only been out for a week, and that was the first question that she asked. So that should give you some indication as to where they stand on that. And then, of course, the I-9 issue continues to be a hot topic as well. Moving on then to the next slide. Where do these audits come from? I think most often these audits come from employee complaints. We have a disgruntled ex-employee who goes to the Department of Labor and claims an overtime issue, claims an off-the-clock work issue, claims a retaliatory discharge issue, and then as a result, you get audited. The most recent audit that I did lasted for 3 full days. I was on site with the investigator of the DOL attempting to manage the employee investigation process for 3 full days. And so it can be a pretty exhausting process for sure. The third-party complaints, you recall the DOL's announcement of the We Can Help program, which is their attempt to, I guess, broaden the types of complaints that they'll consider. So third parties actually are bringing complaints, and audits are resulting from those. And then, of course, the random audits that we discussed earlier. So let's move forward, and Kathy's going to talk to you about the process of what an audit will actually look like.
Okay, as Paul said, you're going to get some sort of notice, and that may very well be a knock on the door, particularly if you're in an industry that uses child labor. And they are really wanting to come in and see whether or not those underage employees are at work. But more than likely, it'll be a telephone call or written notice. And I'm going to use a wage and hour investigation just as an example because it's probably the most common. That telephone call or that written notice should have a description of the issues. And if it doesn't, one of the things that you need to do is get involved and figure out exactly what they're looking for. You have the right to have an attorney or an accountant present during this investigation. You certainly would want to have your HR people and probably upper management involved as well. The first thing that will happen is there will be an on-site, sort of an introductory meeting. That is basically used to explain the purpose of the investigation. It should be used by you to make sure that the scope of the investigation is as narrow as you can make it be. They're going to talk to you about the documents they want to review. Again, you need to try to narrow those documents down as much as you can, although there may not be a whole lot of room for negotiation at this point in time. And they're going to tell you what employees they want to interview. They could interview upper management. They can interview the guy out on the production line. They will want then to take a tour of your facility. And again, this is like a recon gathering matter for them. They're looking to see, just what kind of workplace are you running. Keep them kind of reined in. Don't let somebody wander off into areas that they really have no business running off into. And then they're going to want you to produce, and they're going to want to review your documents. Again, in a wage and hour investigation, that's usually payroll records, personnel files. It should be for a certain period of time. I would not produce anything in addition to what they've asked you to produce. You make sure it's narrow and focused as best you can. Your interviews, remember, you can have someone present during the exempt employee interviews. You may not be able to have someone present during the non-exempt interviews. But again, sometimes that depends on which investigator you draw and what kind of a rapport you developed with that investigator. After all this has taken place, it might be 3 days, like Paul said. They're going to want to sit down and have a closing meeting with you. And they can get pretty darn pushy in this meeting because they're going to want you to agree to certain things in the meeting. You can postpone this to some extent, but they're going to want you to agree to some of their findings. They may want you to agree to a certain amount of back pay that they think you owe. And again, you'll be able to postpone that. You may be able to say, I don't have the authority to enter into this type of agreement at this point in time, but at some point, this negotiation and the push to actually settle will happen. If this doesn't get settled at this administrative level, then it can be referred to the Office of the Solicitor General, and the Department of Labor or the Secretary of Labor itself could actually bring a cause of action against you. More than likely, they'll actually refer and give the complaining party notice that they have a right to pursue a private cause of action. And one other thing that I should mention is they generally won't tell you why they're there. They're not going to tell you it's because of an employee complaint. They won't tell you it's generally whether or not it's just random or if you're part of a target industry. So,
a couple of comments just to touch on some of the things Kathy just mentioned. I've had some success in Department of Labor audits in really limiting the scope of the document requests. Typically when you get a letter or a formal notice of an audit, they will almost always request 3 years worth of documents that show payroll typically, especially payroll, hours worked, some of those related issues going back 3 years. And the reason they picked that time frame is because the FLSA has, at most, 3 years of coverage for employee back pay issues. But I've had, in many instances, a good deal of luck negotiating with the investigator in advance about producing a much smaller time frame, normally because of the amount, the volumes of data that would be involved in producing for every non-exempt employee for a period of 3 years. So you can do some negotiating in advance. You can be somewhat successful with that. But
if you don't ask, they can't say no.
That's right. That's exactly right. And so I've done that. One other thing I wanted to mention was that with respect to the interview process, this is a good example of how the Department of Labor has become more aggressive in all of what it does. It has always been the case that employers are entitled to representation when a management level or exempt employee is being interviewed, as Kathy mentioned. In my most recent Department of Labor audit, I was told by the investigator that she would not permit me to be involved in the interviews with management level exempt employees. So it became a very heated discussion, and ultimately I refused. And I told her that she would not interview the exempt employees without me being present. I would not make them available, that she could, to the extent she felt she had that power, she could go try to compel me to do that through the legal process. But she was adamant that she would not permit me to be a part of that, and ultimately she chose just not to interview those exempt individuals. And her position was that that was going to hurt me because the exempt people might have had information that she wanted to consider in determining whether there was a violation or not. But you should understand why we would want to do that. Exempt level, management level employees can speak on behalf of the company. You can be bound by what they say. So you do not want to participate in those interviews without having someone there to make sure that the interviewer is not manipulating the information that they're receiving.
And one other thing that I'd add to that is if your exempt or management level employees are scheduled to be interviewed, prepare them. Talk to them beforehand. Explain to them what's going to happen. Give them some guidelines on how to answer questions. Don't volunteer. Answer only the question that's put to you. Those kinds of tips. Okay, so it's important then, if you know the Department of Labor is out there, you know that your chances have increased, you may be the subject of an investigation, make sure you're prepared. As Paul said, go through and inspect your physical facilities. Make sure your posters are up. Make sure you have the right poster. And make sure they're all up, because there's a variety of posters that we're required to maintain, not just ones from the U.S. Department of Labor. Go through your policy, your handbooks, and your policies and procedures, and make sure they're current. Are they accurate? Do they actually represent your existing practice? Look at your job descriptions for the targeted area. Are they accurate? Do they represent what the person is actually doing? And look at your record-keeping practices. Are you maintaining the right records for the right period of time? There are requirements from the Department of Labor for different kinds of records. Make sure your supervisors are on the alert for any potential problems or complaints. If you learn through the grapevine that somebody is intending to visit the Department of Labor, you might be able to nip that in the bud if your supervisor's on his or her toes. Talking, Kathy, about the idea of job descriptions, which you touched on, this is another common problem that happens periodically in DOL audits, is that we have job descriptions that aren't particularly accurate, and then when we start trying to defend someone's classification as an exempt employee, we find that the job description doesn't match what the person actually does, and the DOL considers that to be us providing them misinformation. And then they feel like that we're intentionally misclassifying someone because what the job description reads that this person does is not at all what we're telling the investigator that this person does. So if you're going to have job descriptions, and you should, please make sure they're accurate. That's a very important point that Kathy shared there. All right, so let's talk a little bit more about now that we know that an audit is happening, what are we going to do in an audit? What is the right way to do it? First of all, take it seriously.
treat it like a government notice, because that's what it is. I have routinely gotten calls from clients 24 hours before the audit is supposed to start because someone has not paid a lot of attention to the notice or not taken it seriously. If you wait until 24 hours before the audit is supposed to start, it's going to be very difficult for us to negotiate any extension at all of time. So don't delay the response. Be prepared. Start preparing as soon as you get information. You don't have enough time to put it off. Second, a good idea here is to use that initial meeting to develop rapport with the investigator. That actually can be done. The investigators are human. Generally speaking, they're good people. Sometimes we have very strong disagreements because we're advocating for different sides of an issue. But with that said, you can, to the extent you start off an interview in a combative way, it is simply not going to get any better. It's going to snowball from there and become more difficult for us to handle. So typically speaking, most of you in the room here take your obligations under the law pretty seriously. You don't have a lot to hide. We can certainly take that approach in our initial discussions with the investigator and probably find ourselves in a position where we don't get as much scrutiny. Another good thing to do is to identify a single point person, one person that's going to be in charge of communicating with the investigator. When the investigator needs something, they'll go to the same person every time. That person has the opportunity to be more prepared, should have a better idea of how to respond to questions that get asked, and certainly that can be your attorney, that can be your director of HR. Most often when I'm involved in the investigation, I'm the point person for the client. And that's pretty routine.
You control the message as well, too.
That's right. That's right. And then the next thing is make sure you give the investigator a place to work. Give them a designated office space or conference room or something like that where they can station themselves, and you can kind of confine them to one spot so that they're not roaming around the building.
Right.
That's a recipe for disaster. So we want to keep them in one spot if we can.
And this may sound really silly and simple, but giving them an office that's close to a bathroom. If they have to walk across the manufacturing floor to go to and from the restroom, confining them to an office has made no sense.
Right.
So.
And then the last thing that we had on this slide is to make sure you provide the information that they request promptly. The longer that you make them wait, the more time there is for them to think about further issues to investigate. And that is typically what happens. That's why I try to be very prepared in advance. I try to have as much information as I can that was on that list, or an express decision that I'm not going to provide it, so that there's not a feeling of openness to the investigation. I have provided you everything I intend to provide. I'm not providing you the other 3 items on your list. There's no reason for you to wait here any longer. It's done. All right. And then make sure you keep copies of all the documents that you provide. Be cooperative to the extent you can. Make sure that you have your representative decided in advance, someone that can prepare your employees to the extent possible for their investigation interviews. And then take a problem-solving approach with the agency when they decide that you do have issues that need to be resolved. Okay? To the extent you can have that attitude, you're going to have a much better time in negotiating a resolution. Okay? And then finally, ask to get the findings in writing. That's a critical decision. Make sure you get that done so that we have the opportunity, if we need to pursue our other legal protections that are available to us under the administrative proceedings.
Okay, a couple of don'ts. These are pretty obvious, but I'm going to state them nevertheless. Don't avoid telephone calls, and don't avoid their letters. Return those calls promptly. Don't engage in casual conversation. I mean, they're there for a purpose, you're there for a purpose. To the extent you can avoid providing a statement, do it. Don't give them items that are not required. Again, this is all part of narrowing down that focus, making sure you understand what they want and what you're going to provide. And don't let them snoop around. Don't let them go through files that are irrelevant to the investigation or records that are irrelevant. don't discuss other business in front of an investigator. I mean, who knows what the investigator may do with that information. And last but not least, don't enter into a private settlement with the complaining employee to the extent you know who that complaining employee or employees are, because that would not be binding at all.
And then you end up paying that employee twice.
Right.
So.
Okay.
That's it
today.
for us, and at this point I think we have Mr. Nathan Watley and Mr. Curtis Thomas to present our next topic. Thank you very much.
Thank you, Paul. Thanks, Kathy. We've got our mics. Everyone here is okay, or hear me okay? Robin, is it volume okay back there? Well, good morning, everyone. Paul's comment about the Department of Labor investigators being human kind of cracked me up a little bit. Historically, they certainly have been. We're here to talk a little bit about some of the Department of Labor investigators that are from another area, the OSHA area, and sometimes I think they're more Borg than human. Certainly a different approach that they want to take. They're all under the Secretary of Labor, which, we had Hilda Salas until recently. There's a new individual that's been nominated from the Department of Justice, and this makes you wonder if you're going to get more of an advocate, crusader style of enforcement, even more so than we already have. But I think we may have that to look forward to. Number of things that OSHA has been trying to do lately. One thing has been this site-specific targeting. They've been looking for workplaces where they think the highest rates of injuries have been occurring, and programming their inspections. We just wrapped up a national program on energy facilities and chemical plants. That was a big program they had. That one's been wrapped up. We're still in the middle of programmed inspection for nursing facilities. That's still going to be a big area of focus for them. This is continuing. One thing that that we've seen throughout a lot of these programmed inspections is the institution of a new form of discretion. Historically, when OSHA would come out and you would see a fine, it would be toward the lower end of the spectrum. In other words, for different types of violations, they've got a spectrum of fines, not more than a certain amount. We would usually see serious violations come in right around the $2,000 per violation mark. Well, that all changed last year. Internally, they decided these were going to go up around the $5,000 mark, or even up toward the limit, the upper limit of $7,000. So continued aggressiveness there. As I indicated, we're going to see more of this national and regional emphasis on programmed inspections where they've got industries that they want to go out. And much like what was just described with the wage and hour, you're going to have these folks show up at various facilities and say, we're here to inspect. The bad thing is, when OSHA does that, it's not a day or 2 days or 3 days. Sometimes this runs into the months. And they're out there back and forth for many months, and then you may wait even longer for them to come back and issue their findings. So it can be a very involved, very draining, very distracting process. We don't have time to talk about all of the do's and don'ts if that should happen, but a lot of them are similar to what Paul and Kathy talked about in terms of dealing with those wage and hour investigators. One other thing that may not happen this year, but there's definitely been a push for it, and I think there'll be a continued push, is efforts to come in and overhaul the OSHA Act a little bit. There's been a bill introduced in the Senate earlier this month that would expand coverage to public employees as well as private employers. It would also expand it to contractors. As it is now, OSHA only applies to your employees, risks or injuries to your employees. The revisions that have been proposed would expand that and start to create liability in these multi-employer situations where you've got a number of contractors working on the same site or facility, and put liability on that property owner. for both injuries and record keeping. Surprisingly enough, the AFL-CIO has chimed in and said they're all in favor of this. But it doesn't look at this point like there's going to be enough support to get it out of the Senate. One other thing that they want to do, I told you that internally they've already decided to use their discretion to enforce higher penalties when violations are found. What this proposed legislation would do would be to exponentially increase the amount that could be awarded. Instead of $7,000 being the maximum penalty, they want to go to a much higher amount. And then when there's a death, they want to increase that even more. Willful and repeat violations, they're wanting to raise the penalty up to $120,000, just to kind of give you a flavor for what they're looking for. Curtis, you want to talk a little bit about some of the other programs?
And can everybody hear me? Yes? Okay. So OSHA is, and they have been for some time now, working on what is shorthand I2P2, an injury and illness prevention program. And right now, OSHA has just voluntary standards, health and safety management guidelines that are completely voluntary, that an employer can adopt on their own or do on their own. But OSHA is looking to increase their focus on health and safety and looking for, with the theme we've been keeping up with today, more voluntary compliance, and would like to make a mandatory program of an injury and illness prevention program that every employer would have to go through. And when they're going to do this program, although it's in a pre-rule stage at this point, so we don't exactly know what the program will require, they will build on the guidelines of the voluntary health and safety program management guidelines, and they will also build on state guidelines. A lot of states have these voluntary programs in place or incentive programs for employers to adopt an I2P2 plan. The goal is to reduce workplace injuries by proactively finding and fixing workplace hazards. And that's going to be the key there. It's putting the onus on the employer to go out and to be proactive in finding the hazards in their workplace and work as a team, not just management implementing a unilateral plan, but working as a team to find those hazards and work to reduce those. Like I said before, we don't know exactly what the program's going to require. It's in a pre-rule stage right now, but we do think that part of this will be management leadership, employee participation, identifying the hazards, education and training of the employees, and program evaluation. And we'll talk a little bit more about each of those in detail.
Curtis, I think it's worth noting, as we were talking earlier, this reminded us a lot of the Wage and Hour Division's Plan, Prevent, Protect program, where they're putting the onus now on the employers to go out and do their own inspections. And if you haven't done that when they come in to do their audit, you've set up another opportunity for them to find a violation.
Yeah, that's exactly right. And Nathan makes a great point there. This goes along with, the theme of the entire program today has been, increased enforcement activity, increased self-compliance and self-regulation. And if you don't undertake that increased self-regulation, then you're going to get hit for that. You're going to get penalized for that when they do come in and find violations. And so, employer compliance with this new plan is going to be a crucial part of it. And the biggest part of this is this program is going to become a frequently used weapon in OSHA's enforcement arsenal. Nathan talked about the discretion that they have in fines. Well, think when they can tack on, if they can't find a specific hazard violation, you have an injury at the workplace, they can't find a specific violation, well, they've got a catch-all here. your I2P2 plan wasn't sufficient, and if you would have had a better I2P2 plan, that's a mouthful, then this injury would not have happened. And so it's just another opportunity for them to do that. And we've seen that in those states that have these I2P2 plans. This is the most frequently cited violation that they have for their state OSHA agency, their state agency that's similar to OSHA. It's the most frequent enforcement mechanism that they use, and you can guarantee that it's going to be no different once this rule is adopted. So this is kind of a good little diagram, and it's a little bigger up here, but there's really 7 parts of how you should adopt this, and if you don't have a voluntary, if you don't have a safety program in place now, it's probably time to start thinking about what are the hazards in my workplace or in our workplace. What do we need to do to address those? Let's get a safety plan in place. And if you do have one in place, maybe it's time to reevaluate that plan. But 7 parts. 1, management and employees, worker participation, working together to identify hazards. And you see that there. This is, you can call it the belly option, I think. Play, that's what it looks like a little bit. And that joke just failed. Just failed.
I told him he was going to be John Madden with the telestrator earlier.
That's right.
Up here.
Anyway, the other part of that will be hazard prevention and control. And then education and training, once you've identified those hazards and once you've implemented control mechanisms for those hazards, putting those in place. The biggest part of this will be evaluating your program and making sure it works. You can get one in place, but if you don't evaluate it and make sure that it's up to date, then that's when you're going to have issues. And once you do evaluate it, implementing those improvements and starting the process again. So I think Nathan's going to hit on the next slide about incentive programs.
Thank you. Some of you may already be pretty aware of this. We did actually do a webinar that focused on this pretty heavily, but I thought it was worth mentioning again since we had such a big response to that. Last year, OSHA came out with a memo identifying some areas where they were wanting to crack down, not on things that might cause injuries or safety issues, but upon how employers were handling employment decisions that they felt might discourage reporting or discriminate against employees who did report accidents. They touched on 3 things. One was disciplining employees who were injured on the job, just regardless of what the circumstances of the injury were. The second was they frowned on disciplining employees for violating a safety rule, which to me seems a little odd. You'd think they would encourage that. And then third was disciplining employees for the timeliness of their report, and they were concerned about that. So basically any discipline that would come to an employee related to an accident or an injury, they were really concerned might somehow quash the desire to report these accidents and therefore leave an unsafe situation there. The fourth thing, which is really a sort of a catch-22 and goes right along with this, is how do you incentivize your employees and develop a program to prevent these injuries? Well, they were really strong on this, and this is not a new concept for OSHA, but it's something that hadn't really been put into a memorandum like this before. But with this idea that if employers implement a policy that rewards employees for not having accidents, that could somehow discourage the reporting of accidents, and so they're really, really frowning on that. They don't tell us, unfortunately, what's fair game. They want us, again, to make all our own plans, come up with these self-regulating processes. They want to throw out these broad ideas, but they aren't giving us any concrete examples, really. They don't expressly state what incentive programs or across that line that might run afoul of the law. Basically, all they do is give you this sort of general language, it says if it has the effect of discouraging an employee from reporting an injury because they want to hold out for free pizza or a T-shirt, then they're going to find that to be a violation. Of course, the rationale makes some sense that if somebody's going to be under peer pressure because it's a group incentive, or if it's a big enough incentive monetarily, somebody might just kind of gut it out and not say anything and try to make it through the quarter. I don't know how often that really happens. I mean, the feedback I've gotten from clients is that when somebody gets hurt, and if it's a reportable type injury, it doesn't really go quietly unreported. Nevertheless, OSHA wants you to look at that and consider the magnitude of the incentive. You know, is it big enough that it would encourage someone to hide an injury? It doesn't matter what your intention is, because obviously if you put one of these programs together, the intent is really in keeping with OSHA, and that is we want to maintain a safe workplace. We want our people to follow our policies. That's our intent. OSHA doesn't care about why you did it. It's just a question of, does it have this impact? And of course, I don't know how they're going to measure that other than their own subjective viewpoint of it. But you know, once you get into that system, unfortunately, you're dealing with folks that are all part of the organization, making a lot of those determinations, at least at the first few levels. So you don't have a lot of outside oversight until way into the process, and many tens of thousands of dollars have been spent dealing with it. So what would we recommend? Certainly we want to try and focus on things on the front end, on the behaviors that we think will yield better safety results. They talk about that as leading indicators versus lagging indicators. In other words, less focus on just the recordable injuries or the number of injuries, and more focus on what are people doing up front, what participation do we have, what attendance at safety meetings, those types of things. Even instances of use of protective equipment and things like that where there hasn't been an accident, but where you've got people buying into the overall policy.
Go ahead. Can I just jump in? I mean, these are the things we think about when we're talking about the I2P2 program right here. That's exactly the kinds of things as you're developing that program and thinking about this regulation that's coming down the pipe. Those are the things you want to think about when you're developing that safety program or you're reevaluating the program you have in place.
Exactly. Just came up with a couple of slides here with some questions that should all be yes answers. Ask yourself, is your program part of a larger safety incentive? Safety program. Is the incentive meant to work as part of that? Does it include, as we talked about, measuring leading indicators rather than lagging indicators? Does management support it? Do you have buy-in at the top? Does your company involve all levels of employees when you're starting to put this program together and decide what should go into it? Do you provide feedback to employees to let them know whether these goals are being met? Is it stated to them in such a way that everybody in your company can explain what the purpose of the program is? Is that message getting across? Do they understand that this is really about a genuine interest in safety and not just pizzas, T-shirts, days off, whatever it might be? Do you have regular evaluations of that program? And then ask yourself, if you eliminated this, would it suddenly result in more people reporting accidents or injuries? Like I said, we did talk about this at some length in a webinar. We've got a memorandum on this on our McAfee Taft website. If anybody would like to look for that, it's on the McAfeeTaft.com under the resources and attorney articles. Talks about OSHA sharpens focus on employer safety incentives to give a little more information on that. Finally, we want to talk a little bit about whistleblower initiatives. And again, it kind of parallels some of the things we're seeing in the Wage and Hour with their We Can Help program and the iPad apps and things like that, where they're wanting employees to report in and get DOL involved.
Well, that's right. Nathan's exactly right. And Paul and Kathy referenced the We Can Help program. But basically, the DOL has a series of initiatives that are designed for employees to be able to report and assist them in reporting problems with their employer, whether it be their compensation, they're not being paid overtime, or they're not being paid for all the work they're doing, or whether it be they think there are issues with the safety in the workplace. There's just been a general emphasis on increasing an employee's ability to report that to the agency, and not only report it to the agency, but the agency is taking that seriously and taking those complaints seriously and stepping up their investigative and enforcement efforts to look into those complaints and take them seriously. So we saw an increase in the fiscal year 2012 in the number of whistleblower cases filed. It was up 5% from fiscal year 2011. We also saw an increase tracking with they're taking this seriously of almost 50% in the number of determinations that they've made. So not only have they taken the complaints in, but they're working those complaints, they're investigating them, they're going to the employer, knocking on the door, and looking at what's going on in the workplace. The good news is employers are generally in compliance with the law. Less than half, less than 0.25% produced settlements, and just 2% resulted in a preliminary order or an order that the employer was in violation of an OSHA regulation. So those are very low numbers, and a large majority of those, 58%, were actually just dismissed completely. So the good news is employers are in compliance. The bad news is there's just more scrutiny on you no matter what, and so you've got to make sure that you are in compliance with the OSHA regulations. The whistleblower program's also been restructured somewhat by OSHA, and this again goes to their increased attention to and giving more importance to this. They've made some internal changes to the training they are giving their investigators, to the enforcement initiatives that are handed down by the administrators in OSHA to those investigators, and they're really focusing on increasing. There's over 20 whistleblower laws that OSHA just has coverage over, and they're increasing enforcement of that. There's even a website, whistleblowers.gov, where you can get all the information you need to blow the whistle on the employer, or your employee can get all the information he needs. And this is very dry, but the whistleblower enforcement's got in an elevated status within the agency. It's been reassigned to a point to the Department of Labor's Office of Assistant Secretary, which is a much higher profile reporting position than where it was previously with the Directorate of Enforcement Programs. So it is a priority. We are going to see more whistleblower claims from employees. It's just a fact. Finally, and related to this, and related to kind of the theme overall, is OSHA has taken steps and taken significant steps along with the DOL overall in general to improve public access and create this enforcement database. Paul talked about earlier, the DOL is working with state agencies on misclassification of independent contractors so they can increase revenue. So they're creating a database, a shared database, so they can all look at how you've classified your employee and make those determinations of whether you're correct. It's the same idea here. Let's make the employer's record of complying with OSHA's regulations. If they've been cited before, what kind of penalties that the employer has been given before. Let's make that public record. Let's not only make it public record, let's make it very easy to access. And all that does is, if you do have the disgruntled employee who has complaints, it gives them more access and more ammunition to come after you and to bring those whistleblower claims or bring those other types of claims. So, Nathan, do you have anything to add to that?
No, I think the message is pretty clear.
Yeah, I think we've hit on that theme quite a bit there.
Appreciate your attention. We are going to have another short break of about 15 minutes. If you guys can be back promptly, we'll start back at 10:50 with the program on the EEOC. Thank you.
Thank you, guys.